Hello, everybody. Welcome back to Radio Entrepreneurs as we continue this week to stream stories of how people are dealing with this economy and blurring our screens. My name again is Jeffrey Davis, and every week we like to check in on our segment Entrepreneurship and the Law with Mark Furman, shareholder at the law firm of Tarlow, Breed, Hart, and Rodgers. Hello, Mark.
Jeffrey, great to be with you today.
Thank you very much. And we are always glad to hear from you and understand how the law affects business and how business affects the law. There's always a hot story for you to work with today.
Well, this is an important week and an important day, actually, because today is the closing arguments in the trial involving former President Trump in New York State Court. So we'll be closing arguments today. Then the judge will instruct the jury on what the law is that they need to apply. And then the jury will begin its deliberations, and we'll either have a guilty, not guilty, or a hung jury probably by the end of the week. So it's a pretty historic time. So from news reports that I heard, under New York law, the defense goes first in closing arguments, and then the prosecution goes next. And one of the interesting things about the trial, to me at least, as a lawyer, is who gets put on the stand as a witness and who doesn't. And the decision not to put on the stand Alan Weisselberg is a very interesting strategic decision. He's in jail on a perjury charge, and but he was very much a key witness, along with Michael Cohen and former President Trump. So Cohen testified. He has significant baggage as a witness. Trump exercised his constitutional right not to testify. The jury isn't supposed to draw any inference from his failure to take the stand. And Weisselberg, who was available to testify, just because he's in prison doesn't mean he can't be brought to court to testify as a witness. And the prosecutor decided not to put him on for whatever reason. But these are the kinds of strategy decisions that lawyers need to make, whether they're on, no matter which side they're on. Who do you call? Do the risks are they outweighed by the potential benefits or not? I always say a lot of times there's witnesses and documents that are both helpful and harmful, and everybody has to make a decision about whether things help more than they hurt or hurt more than they help. So I think Weisselberg is kind of a classic case where, one more witness who has baggage in the case. So we'll see what happens. It'll certainly be a historic decision, and it's tied very much into our politics in this country and the presidential campaign and fundraising, and so it'll be interesting to watch. And
there were so many potential trials that could have happened with the ex-president, and this one, which seems to have lasted right to the end, is one that the public doesn't seem to be very interested in. And I find that interesting as well. It just seems like all the witnesses are people are not credible to anybody, and Even the ex-president seems to want to doze off in trial and not and not really participate other than his politicking outside the courtroom. It's really kind of a shame that, the way this whole thing has sort of played its way out.
Well, the case is in some ways quite technical. In many ways it's a document case, but non-disclosure agreements have been very common. Settling with someone to in exchange for confidentiality or non-disparagement agreement, certainly not uncommon. Here you have the allegation of falsifying business records by these invoices and payments to Michael Cohen. And I wouldn't say it's, I question whether if it wasn't former President Trump, would the case have been brought. It's not like the January 6th case.
Right.
It's not like the Georgia election interference case. And it's not even like the classified documents case. This requires, showing this falsification of business records for the purpose of, impacting the election, not to protect, President Trump's family or from embarrassment from his family, his wife, his kids. So it's not a case that has overriding importance to our country, as opposed to the January 6th case, which won't be heard before the election, which I think really is, something that it would be good for people to know what happened. I do wish that this was, was on television and streamed, because, the fact that the former president is being prosecuted for crime, I think it would be good for the public to be able to see it, like the Watergate hearings for people of a certain age, or the O.J. Simpson trial. So I don't know. To me, you're relying on people's interpretations of events that occurred in court. And even when news outlets read from the transcript, it's sometimes referred to as the naked transcript. It doesn't communicate the emotion, the demeanor, the credibility or lack of credibility. It's just words on a paper when you're talking about a transcript. So I wish that that was available to the public in a case like this.
Very interesting. And again, I would agree with you. This is not necessarily the trial that will move the needle, which is too bad. I think there was a bigger case out there that a lot of Americans would have liked to have seen clarified for us. But it does have implications for entrepreneurs too, and that is, be careful what you do, be careful the deals you make behind closed doors, because things can catch up with you. And if you're in business, there are implications.
Absolutely. And, the idea of falsifying business records is a big deal for all business owners. You got to be careful. We have such a highly regulated society with so many rules and laws and traps for the unwary, and nobody can be knowledgeable about all the technicalities of the rules. But
Right.
here, these payments were to Cohen, the reimbursement payments were structured in a particular way. And one of the questions is whether that was truthful or whether they were falsified business records, whether this was a legal fee, which is how they were characterized, or whether they should have been characterized as something else, like a reimbursement. And then you have all the payments were grossed up to deal with taxes, and then you have the payments were intended for other things, not just the Stormy Daniels thing. And I think Cohen admitted that he was reimbursed, he was paid in order to resolve something at a particular amount. He resolved it for less and pocketed the difference. Plenty of baggage with Michael Cohen. But I think the documents themselves are a problem for President Trump. So we'll see what the jury does, and we'll see what the reaction is. And the politics are going to overwhelm the legal process, probably, no matter what happens.
Well, and we know you'll be around next week when we do have a decision. Again, we've been speaking with Mark Furman, director, shareholder, Tarlow, Breed, Hart, and Rodgers for our segment Entrepreneurship and the Law. Mark, if someone wants to connect with you, how would they do that?
I can be reached at Furman, Furman, at TBHR-law.com.
Great. And remind everybody, this is Radio Entrepreneurs.